Our commentator for this panel is Professor Tanina Rostain of New York Law School. Tanina is an expert in legal ethics and the legal profession. Tanina?
Thank you. Mark, Suzanne, who I know is here somewhere, thank you so much for putting together such a spectacular conference, and it's clearly, having heard your conversations at the beginning and how much thought you put into the different panels and the different themes, it's clearly the fruition of your work is obviously evident here and yesterday and today. And thank you for asking me to be a commentator on this panel. I've been assigned the task of commenting on 3 very interesting papers that address different aspects of relations between Jewish and non-Jewish lawyers in the New York private bar during the first 50 years of the 20th century. If Sam Levine's and Steve Flanders illustrate Jewish success stories during the earlier part of the century, Larry Mitchell's paper tells us how the ruling corporate bar in the early 50s, or actually the mid-40s, enacted purportedly neutral legislation that targeted specifically Jewish lawyers and their clients. Now, the early 20th century was a formative period in the American legal profession, and a lot of people in this room are familiar with the general history, but I think it's worth highlighting some of the moments in the formation of the American bar. And because the early 1900s saw some of the appearance of some of what we associate as the formal characteristics of the American legal profession. First of all, the period was marked by certain standardization of teaching methods and institutionalization of educational requirements. The teaching method, as many of the people in the room are familiar, originated with Christopher Columbus Landell's Socratic method in 1870, and that form of teaching spread to law schools throughout the country in the early 20th century. And in addition to that, states institutionalized educational requirements. One interesting statistic, in the 1890s, there was an estimated 80% of lawyers had not gone to law school. And the preferred mode of training to become a lawyer was apprenticeship. 3 decades later, law school was the mode of entry for almost everybody. So in 3 decades, we went from apprenticeship to a formal education. In the early 20th century, state bars had instituted bar exams as a precondition of being admitted to the bar. And in addition to that, in the 1920s and 1930s, the different state bars had also added character and fitness requirements, which were aimed in particular at immigrant would-be entrants to the bar. Now, during the first half of the century, we also saw the enactment of and the expansion of prohibitions against the unauthorized practice of law. Around the turn of the century, these focused specifically on non-lawyers representing clients in court. By the Great Depression, the definition of practice of law had been expanded significantly. There were active unauthorized practice committees in every state who were busy trying to crack down on unauthorized practice, and among others, they were going after non-lawyers who were doing document preparation, who were giving legal advice. And so we're working under a much more expanded conception of what practice of law was. So those were some of the formal aspects of the professionalization project of the American lawyers. At the same time, in the early 20th century, there was a sea change in the dominant type of practice and the organization of practice and the types of ideals that animated the legal profession. And these transformations, which Mark Galanters described very eloquently in books and articles, involved in particular a switch from a conception of lawyers, of great lawyers, of being individual practitioners who made their reputations by representing clients in court, and who occasionally were engaged in affiliations with other lawyers who were generalists, but who didn't practice in firms. And in fact, the corporate firm came into being in the late 19th century with the system that soon became known as the Cravath system, pioneered by Paul Cravath at Cravath, Swaine, and Moore. And under the Cravath system, there's a system of training where Cravath and his firm recruited mostly, almost all, WASP new lawyers from very elite law schools, train them, and in exchange for their hard work and their loyalty and their commitment over a certain period of time, made them partners. So that was an institution that we consider a permanent part of the American legal landscape, and in fact has a history connected with the early 20th century in terms of its organization and training. In addition to that, and this is another piece that was particularly important, I think, as a backdrop to the stories that we heard here, lawyers no longer represented individuals, but in fact the corporate lawyer became the ideal of the elite lawyer, and through firms like the Cravath firms that developed long-standing relationships with corporate clients, which had them on long-term retainers, and who were loyal to clients. The firms and clients were loyal to each other over long periods of time. Example that comes to mind is the decades-long relationship between IBM and Cravath, Swaine, and Moore. For a very long time, Cravath was IBM's lawyers, and they did all the work for IBM. So this is into the beginning of the early 20th century, we saw that there was now an alignment between what were considered elite lawyers and corporations, and elite lawyers were seen more and more as aligned with the interests of business. And in fact, this was this alignment was criticized by Louis Brandeis in his wonderful speech, The Opportunity of the Law, which he gave in 1914, and he noted in that speech the increasingly cozy relationship between elite lawyers and corporations, as he observed, quote, instead of holding a position of independence between the wealthy and the people, prepared to curb the excesses of either, able lawyers have, to a large extent, allowed themselves to become adjuncts of great corporations and have neglected the obligation to use their powers for the protection of the people. He goes on to observe that the leading lawyers of the United States have been engaged mainly in supporting the claims of corporations, often in endeavoring to evade or nullify the extremely crude laws by which legislatures sought to regulate the power of the excesses of corporations. So, the profession, and one more piece of this background story, the story of professionalization and the shift to elite corporate practice as the ideal is seen in the early history of the Association of the Bar of the City of New York, which was formed in 1970, and as Robert Gordon has written, the ABCNY was formed from a real mix of motives. On the one hand, a powerfully reformist agenda where they're trying to address the excesses of Tammany Hall. On the other hand, elitist exclusionary attitudes concerned with, among others, or in particular, the lowering of standards because of new Jewish immigrants coming in and into the bar and becoming lawyers. So this is the backdrop against which I read these papers, and these papers in different ways ask the question, how do Jews fit into this story? And in the early part of the century, as I hear listen to Sam and Steve's papers, I heard a story of stories of Jewish success. If we start thinking about Steve's story, it's a story about an alternative organization that gets formed, that's committed to principles of equality. It's formed, of course, in response to blatant anti-Semitism in the judicial selection process. It's committed to be open to everyone who meets the high standards of the bar, and it shows an opening, and particularly through collective activity and organized activity in law, where lawyers can not only form or Jewish and other lawyers can not only form their own organization, it becomes a very powerful organization, and in fact it ends up co-opting the most influential members of the New York bar. And so it's a story of success, of space, of movement, of forward-lookingness that is afforded both by who are the lawyers at the time, but also the vision of law that animates the creation of the New York County Bars Association. And it also and Steve's story also undercuts the idea that we have insiders and outsiders, that in fact there's a lot of fluidity between insiders and outsiders, that in fact the people we assume are insiders, in fact, were once outsiders, and that the outsiders can become insiders. Exhibit 1, the New York County Bar Lawyers Association. So a story of success and of forward motion. Then I